Hello and welcome to Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we upload content every single day at 8 a.m. Eastern Standard Time. Whether you're listening to this for the purposes of the bar exam or just simply to prepare yourself for your law school exams, we hope to be of help. Let's look at question number 1. Pocket, a bank vice president, took substantial kickbacks to approve certain loans that later proved worthless. Upon learning of the kickbacks, Dud, the bank's president, fired Pocket, telling him, "If you're not out of this bank in 10 minutes, I'll have the guards throw you out bodily." Pocket left at once. If Pocket asserts a claim against Dud based on assault, will Pocket prevail? A, no, because the guards never touched Pocket. B, no, because Dud gave Pocket 10 minutes to leave. 3, yes, if Dud intended to cause Pocket severe emotional distress. Or D, yes, because Dud threatened Pocket with a harmful or offensive bodily conduct. Take 10 seconds. If you chose option B, no, because Dud gave Pocket 10 minutes to leave, you'd be correct. Assault is the intentional creation of reasonable apprehension of imminent harmful or offensive conduct or contact. Here, the imminent element of assault is missing, since Dud gave Pocket 10 minutes to leave before Dud would order the guards to throw Pocket out. As such, Pocket will not prevail on a claim of assault because Dud gave Pocket 10 minutes to leave. Question number 2. Donna was arrested and taken to police headquarters, where she was given her Miranda warnings. Donna indicated that she wished to telephone her lawyer and was told that she could do so after her fingerprints had been taken. While being fingerprinted, however, Donna blurted out, "Paying a lawyer is a waste of money because I know you have me." At trial, Donna's motion to prevent the introduction of the statement she made while being fingerprinted will most probably be A, granted, because Donna's request to contact her attorney by telephone was reasonable and should have been granted immediately. B, granted because of the fruit of the poisonous tree doctrine. C, denied because the statements were volunteered and not the result of an interrogation. Or D, denied because fingerprinting is not a critical stage of the proceeding requiring the assistance of counsel. Take 10 seconds. Choose your best answer now. If you chose option C, denied because the statements were volunteered and not the result of an interrogation, you'd be right. Under the Fifth Amendment, there's a right against self-incrimination. The Miranda warnings must be given to anyone in police custody before police interrogation. Police interrogation is any conduct that the police know or should have known was likely to elicit an incriminating response from the suspect. A spontaneous statement, however, is a statement by the suspect that was not made in response to police interrogation. In this case, Donna was being fingerprinted when she made her spontaneous statement. The police were not engaging in any conduct likely to elicit an incriminating response from Donna, so they were not violating her Fifth Amendment right against self-incrimination when she made her spontaneous statement. Therefore, Donna's motion to prevent the introduction of the statement will most probably be denied because the statements were volunteered and not the result of interrogation. Let's look at option A, granted because Donna's request to contact her attorney by telephone was reasonable and should have been granted immediately. The law does state that the defendant has to be granted an opportunity to speak to an attorney if they ask for it, but there's nothing in it that says that has to be immediate, so A is a misrepresentation. B, granted because of the fruit of the poisonous tree doctrine. Again, not especially relevant because for there to be a fruit of the poisonous tree argument, there has to be a poisonous tree. Here, there is no poisonous tree because the statement was blurted out not under an interrogation. So, as a result, B would not be applicable. D, denied because fingerprinting is not a critical stage of the proceeding requiring the assistance of counsel. D does not seem to be on point simply because the question is not whether this was a critical stage of the proceeding requiring counsel. She had already made a request for counsel. The issue really here is whether her statement was appropriate with regards to being let in or whether it would be inadmissible subsequently. Question number 3 now. Season and Vendy standing on Greenacre, orally agreed to its sale and purchase for $5,000 and orally marked its bounds as that line of trees down there, the ditch that intersects them, the fence on the other side, and that street on the fourth side. In which of the following is the remedy for reformation most appropriate? Option A. As later reduced to writing, the agreement by clerical mistake included 2 acres that are actually beyond the fence. Option B. Vendee reasonably thought that 2 acres beyond the fence were included in the oral agreement, but Season did not. As later reduced to writing, the agreement included the 2 acres. C. Vendee reasonably thought that the price orally agreed upon was $4,500, but Season did not. As later reduced to writing, the agreement said $5,000. Or D. Vendee reasonably thought that a dilapidated shed backed up against a fence was to be torn down and removed as part of the agreement, but Season did not. As later reduced to writing, the agreement said nothing about the shed. Take 10 seconds and choose what you believe to be the best answer now. If you chose option A, as later reduced to writing, the agreement by clerical mistake included 2 acres that are actually beyond the fence, you'd be correct. Reformation is an equitable remedy in contracts where the court alters the parties' written agreement to conform with the parties' original intent and understanding. When the mistake is unilateral, reformation is denied unless the other party knows of the other's mistake. If mistake, however, is mutual, reformation is granted. In this case, Season and Vendee agreed to the sale and purchase of Greenacre for $5,000 and orally marked its bounds as that line of trees down there, the ditch that intersects them, the fence on the other side, and the street on the fourth side. Since the equitable remedy of reformation is granted when there is mutual mistake, reformation would be granted if the agreement, as later reduced to writing, included 2 acres that are actually beyond the fence by clerical error. As a result, the error would have been mutual, and as a fact, A would be the most appropriate response. Question number 4. Green is cited for contempt of the House of Representatives after she refused to answer certain questions posed by a House committee concerning her acts while serving as U.S. Ambassador. A federal statute authorizes the Attorney General to prosecute contempts of Congress. Pursuant to this law, the House directs the Attorney General to begin criminal proceedings against Green. A federal grand jury indicts Green, but the Attorney General refuses to sign the indictment. If the Attorney General signs the indictment, the strongest argument Green could urge as a defense is that A. Green may refuse to answer the questions if she can demonstrate that they are unrelated to matters upon which Congress may legislate. B. The House may question Green on matters pertaining to the expenditures of funds appropriated by Congress. C. Only the Senate may question Green on matters that relate to the performance of her duties. Or D. Congress may not ask questions relating to the performance of duties executed by an officer of the executive branch. Take 10 seconds. Choose your best answer now. If you chose option A, Green may refuse to answer the questions if she can demonstrate that they are unrelated to matters upon which Congress may legislate. You'd be correct. Congress may exercise all powers enumerated in the Constitution and any power necessary and proper to carry out the legislative power. Under the Necessary and Proper Clause, Congress may use any means not prohibited by the Constitution to carry out its authority. This is not an independent source of congressional power, but rather authorizes Congress to exercise powers expressly granted to it. The power of Congress to investigate to secure information as a basis for potential legislation or official action, such as impeachment, is implied from Necessary and Proper Clause. Congress may also appoint its own members to investigative committees. Here, if the questions posed to Green were related to something Congress can legislate, then these questions were within Congress's investigatory power, and Green could be found in contempt for refusing to answer. However, if the questions were outside of the scope of Congress's legislative powers, then Green would not be in contempt for refusing to answer. Therefore, Green may refuse to answer the questions if she can in fact demonstrate that they are unrelated to matters upon which Congress may legislate. Question number 5. In a narcotics conspiracy prosecution against Daly, the prosecutor offers in evidence a tape recording of a telephone call allegedly made by Daly. A lay witness is called to testify that the voice on the recording is in fact Daly's. Her testimony, to which of the following would be the least sufficient basis for admitting this recording? A. She had heard the same voice on a similar tape recording identified to her by Daly's brother. B. She had heard Daly speak many times, but never over the phone. C. She had specifically, for the purpose of preparing to testify, talked with Daly over the phone at a time after the recording was made. Or D. She had been present with Daly when he engaged in the conversation in question, but had heard only Daly's side of the conversation. Take 10 seconds and choose which one you think would be the best answer now. If you chose option A, you'd be correct. She had heard the same voice on a similar tape recording identified to her by Daly's brother. A witness's lay opinion testimony is admissible if it is rationally based on the witness's own perceptions, will be helpful to the trier of fact, and is not based on scientific or other specialized knowledge. A lay opinion identifying a voice is admissible if foundation is first laid showing the witness's familiarity with the voice. The authentication requirement for an item of evidence is met if the proponent produces evidence showing the item is what the proponent claims it to be. Under the federal rules of evidence, an opinion identifying a person's voice based on hearing the voice at any time under circumstances that connect it with the alleged speaker satisfies the authentication requirement. Here, the difference between A and the other answer options is that the lay witness in A does not have personal knowledge of what Daly's voice in fact sounds like. In B, she spoke with Daly in person. In C, she had talked with Daly over the phone. In D, she heard Daly in person. Only in A do we see that she identifies the voice because someone else told her she is hearing Daly's voice. Thus, answer option A would be the least sufficient basis for admitting the recording into evidence. Question number 6. Driving down a dark road, defendant accidentally ran over a man. Defendant stopped and found that the victim was in fact dead. Defendant, fearing that he might be held responsible, took the victim's wallet, which contained a substantial amount of money. He removed the identification papers and put the wallet and money back into the victim's pocket. Defendant is not guilty of A. Larceny, because he took the papers only to prevent identification and not for his own use. B. Larceny, because he did not take anything from a living victim. C. Robbery, because he did not take the papers by means of force or putting in fear. Or D. Robbery, because he did not take anything of monetary value. Take 10 seconds and choose what you believe to be the best answer now. If you chose option C, robbery, because he did not take the papers by means of force or putting in fear, you'd be correct. Robbery is larceny plus force or threat of immediate harm. Larceny is the wrongful taking and carrying away of another's tangible personal property without consent and with the intent to permanently deprive. In this case, defendant took the victim's identification papers with the intent to permanently deprive them from the victim. However, the defendant did not use any force or threat of immediate harm to do so, since the victim was in fact dead. Defendant is guilty of larceny, not robbery. Therefore, defendant is not guilty of robbery because he did not take the papers by means of force or putting in fear. Question number 7. Fruitco Inc. ordered from Orchard Inc. 500 bushels of number 1 Royal Fuzz peaches at a specified price for prompt shipment. Orchard promptly shipped 500 bushels, but by mistake shipped number 2 Royal Fuzz peaches instead of number 1. The error in shipment was caused by the negligence of Orchard's shipping clerk. Which of the following best states Fruitco's rights and duties upon delivery of the peaches? A. Orchard's shipment of the peaches was a counteroffer and Fruitco can refuse to accept them. B. Orchard's shipment of the peaches was a counteroffer, but since peaches are perishable, Fruitco, if it does not want to accept them, must reship the peaches to Orchard in order to mitigate Orchard's losses. C. Fruitco must accept the peaches because a contract was formed when Orchard shipped them. Or D, although a contract was formed when Orchard shipped the peaches, Fruit Co. does not have to accept them. Take 10 seconds and choose the best answer now. If you chose option D, although a contract was formed when Orchard shipped the peaches, Fruit Co. does not have to accept them. You'd be correct. Under the UCC, an offer to buy goods for prompt shipment can be accepted by a promise to ship the goods or prompt shipment of conforming goods. Shipment of non-conforming goods in response to an offer to buy is an acceptance and breach. If tender is less than perfect, then the buyer can 1. Reject all the goods and sue for damages. 2. Accept all the goods and sue for damages. Or 3. Accept some, reject the non-conforming goods, and sue for damages. Here, Fruit Co. offered to buy 500 bushels of number 1 Royal Fuzz peaches for prompt shipment, and Orchard promptly shipped non-conforming peaches. Orchard's prompt shipment acts as an acceptance of Fruit Co.'s offer, even though the peaches were non-conforming. A contract had formed between Orchard and Fruit Co., but because the goods were non-conforming, Fruit Co. does not have to accept them. Therefore, the best statement of Fruit Co.'s rights and duties upon delivery of the peaches is that although a contract was formed when Orchard shipped the peaches, Fruit Co. in fact does not have to accept them. Question number 8. Until 1954, the state of New Atlantic required segregation in all public and private schools. But all public schools are now desegregated. Other state laws enacted before 1954 and continuing to present provide for free distribution of the same textbooks on secular subjects to students in all public and private schools. In addition, the state accredits schools and certifies teachers. Little White School, a private school that offers elementary and secondary education in the state, denies admission to all non-Caucasians. Stone School is a private school that offers religious instruction. Which of the following is the strongest argument against the constitutionality of free distribution of textbooks to the students at the Little White School? A. No legitimate educational function is served by the free distribution of textbooks. B. The state may not in any way aid private schools. C. The Constitution forbids private bias of any kind. Or D. Segregation is furthered by the distribution of textbooks to these students. Take 10 seconds and choose what you believe to be the best answer now. If you chose option D, segregation is furthered by the distribution of textbooks to these students, you'd be correct. The Equal Protection Clause of the 14th Amendment applies equal protection to the states. Equal protection is invoked when a law treats one person or class of persons differently from others. Equal protection further provides that all citizens must be offered the equal protection of the laws. While the Constitution generally only applies to state action, the entanglement exception says that an entity must comply with the Constitution if the government has authorized, encouraged, or facilitated the unconstitutional conduct. The Supreme Court has found state action, if it provides tangible aid like free textbooks to schools that practice racial or other invidious discrimination, because it encourages continued discrimination. Here in New Atlantic, state laws provide for free distribution of the same textbooks on secular subjects to students in all public and private schools. Little White School is a private school that denies admission to all non-Caucasians. New Atlantic, as a result, violates the Equal Protection Clause of the 14th Amendment when it freely distributes textbooks at Little White School. Although the book distribution law is intended to help all students, regardless of race, its effect by supporting private schools like Little White School is to further encourage discrimination. Therefore, the strongest argument against the constitutionality of free distribution of textbooks to students at Little White School is that segregation is furthered by the distribution of textbooks to these students. Question number 9. In an action to recover for personal injuries arising out of an automobile accident, plaintiff called bystander to testify. Claiming the privilege against self-incrimination, bystander refuses to answer a question as to whether she was at the scene of the accident. Plaintiff moves that bystander be ordered to answer the question. The judge should allow bystander to remain silent only if A. The judge is convinced that she will incriminate herself. B. There is clear and convincing evidence that she will incriminate herself. C, there is a preponderance of evidence that she will incriminate herself. Or D, the judge believes that there is some reasonable possibility that she will incriminate herself. Take 10 seconds. If you chose option D, the judge believes that there is some reasonable possibility that she will incriminate herself, you'd be correct. If it appears to the court that the witness's testimony may tend to incriminate the witness, then the witness may invoke the Fifth Amendment privilege against self-incrimination. Under the federal rules of evidence, when the relevance of evidence depends on whether a fact exists, proof must be introduced sufficient to support a finding that the fact does in fact exist. In this case, bystander refused to answer a question as to whether she was at the scene of the accident by claiming the privilege against self-incrimination. If the judge thinks the testimony may tend to incriminate bystander, then the judge will allow bystander to remain silent. Therefore, the judge should allow bystander to remain silent, but only if the judge believes that there is some reasonable possibility that she will incriminate herself. And question number 10, suspecting that students were using narcotics, the president of a private college arranged for local police to place concealed microphones in several suites of the dormitory. Using these microphones, the college security officers recorded a conversation in which Green, a student, offered to sell marijuana to another student. The tape was turned over to local police, who played it for a local judge. The judge issued a warrant to search Green's room. The room was searched by police, and marijuana, in fact, was discovered. Green is charged with unlawful possession of narcotics. At trial, Green's motion to prevent the introduction of the marijuana into evidence will most probably be A, denied because the college president, in loco parentis, had the responsibility of preventing unlawful activity by students under the president's supervision. B, denied because there was probable cause to make the search and police obtained a warrant before commencing the search. C, granted because Green's privacy was unreasonably invaded. Or D, granted because the electronic surveillance was fundamentally unfair. Take 10 seconds and choose what you believe to be the best answer now. If you chose option C, you'd be ending on a great foot, as you'd be correct. Granted, because Green's privacy was unreasonably invaded. If a defendant's constitutional rights are violated in connection with a criminal prosecution, the exclusionary rule, a judge-made doctrine, requires the exclusion of all evidence obtained in violation of such rights and all derivative evidence. The Fourth Amendment prohibits unreasonable searches and seizures. Unreasonable searches and seizures have been deemed to be those involving state action that intrude upon an individual's reasonable expectation of privacy. A suspect has automatic standing when the place searched is where the suspect in fact lives. The police may search without a warrant if the suspect gives voluntary and intelligent consent to the search. A search is not valid if the consenting party did not actually have the authority to consent and the police could not reasonably believe the party consenting had the authority to do so. Here, the president of a private college arranged for local police to place concealed microphones in several dorm suites. The local police did not have a warrant to place the microphones. Additionally, the local police did not have valid consent to place the microphones, since the police could not have reasonably believed that the president of a private college had the authority to consent to place microphones on dorm suites. The recording of Green's offer to sell marijuana was obtained in violation of Green's reasonable expectation of privacy. Under the exclusionary rule, the marijuana obtained as a result of this violation will be excluded from evidence. Therefore, Green's motion will most probably be granted because Green's privacy was unreasonably invaded. As always, thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. As usual, to that end, we upload content every day at 8 a.m. Eastern Standard Time. Don't forget to like, subscribe, and click the notification bell so you can be updated every time we upload new content.